That's fine.
Good morning, gentlemen. My name is Jimmy Drury. I represent Miss Gaskin and her nephew, James Warner, in this case. This case originated in Tipton County, Tennessee.
Do you wish to reserve any time for rebuttal?
I wish to reserve 3 minutes, Your Honor.
3 minutes, okay.
This case is a conservatorship case, which should have never been a conservatorship case because I was a power of attorney in existence. But to go back in time, on September of 2022, Ms. Gaskin has an attorney in fact in this case. There was nothing happened until this December of 18th of 23. At that time, the plaintiff petitioner, for some reason, takes Ms. Gaskin to a doctor and has to get an affidavit showing she's incapacitated. It just so happened that she also was sick that day, evidently. She was suffering from flu. And on the next day, Ms. Gaskin, evidently, according to their testimony, their affidavit or pleadings, stumbled and had to go into the hospital. She went to the hospital. She had sepsis and some other problems with her body, and it's all set forth in the pleading. And then she stayed in the hospital, Methodist Hospital, for a while, and then got into rehab at a local facility there in Memphis, and stayed in there until February the 15th. Now, in the meantime, on January the 12th, Ms. Gaskin had been having problems with this respondent, petitioner rather, living with her on and off, and she heard it through the grapevine, and she wanted to put her in a nursing home or a facility up near Nashville where she was at. Well, Ms. Gaskin would have any part of that. She sent a letter.
Hold on just a second.
I'm sorry.
Is all this, what you're relating to us, is this in the record?
I'm sorry.
Is this in the record?
Yes.
It is?
The letter is in there. The letter is in there for sure.
I understand, but there's no transcript or statement of the evidence.
Okay.
And
Okay.
a lot of what you're saying, I'm just wanting to make sure is in the record.
Well, okay, there's a letter in there Ms. Gaskin sent. It's in part of the record showing that she didn't want this lady around anymore, the petitioner around anymore. She didn't get the letter until the 22nd. I can tell you why. It was a snowstorm in Memphis at that time, but it was a little late. But she got on the 22nd, and that's when this petition was filed, on the 22nd, okay? Now, this petition said, among other things, that she was disabled, and attached this affidavit that this doctor wrote on December the 18th, one day before she went in the hospital. And also mentioned that there was that my client, Mr. Warner, had a power of attorney, and they acknowledged that he had one in this pleading. Okay, we go, and they filed an emergency petition also at the time on the 22nd. The emergency petition was eventually was dismissed because of no hearing was held in 5 days. It was dismissed. We filed a petition Mr. Warner filed a petition in that case to tell him he had a power of attorney, and also in case his power of attorney wasn't valid or was overcome, then he wanted to be the conservator. This was we had a couple of hearings on this. The court was informed about the power of attorney. The court rejected it, and wouldn't even rule on it. There was no ruling on it, and it was part of the record. Also, let's see. We went ahead with some hearing, and also at the hearing, plaintiff's petitioner's counsel filed a motion to withdraw for me to said I couldn't represent the parties because they said they were liable to call me as a witness. There never was any hearing or I still don't know what I was going to be called as a witness about. I didn't say I was. I know that you can be an advocate and a witness at the same time, but I had no intention of being an advocate, of being a witness in this case. I didn't have to be. But this was filed to prevent me from handling this case for Ms. Gaskin and her nephew.
Which poses a somewhat interesting question for me, Mr. Drew. The trial court disqualified you from representing Mr. Warner, is that correct?
Well, I guess that's what it was at that time, okay? So that left me open to represent Ms. Gaskin.
Okay.
But I'll tell you what happened on that.
Well, hold on and let me ask you a couple of questions, okay? Let's do that. So if you're disqualified, you're disqualified according to the last order from the trial court representing Mr. Warner. Are you representing him here today on appeal?
Yeah, I'm representing Ms. Okay, before I'll tell you what my situation is. Before the trial date on the hearing was the 6 days after she got served, not 7, like it's required by statute. Ms. Gaskin contacted me and wanted me to represent her.
Hold on, is this in the record?
It's not a record of it because I told it to the court. I said Ms. Gaskin called me.
I understand, but what we review are the pleadings and the transcripts and the statement of evidence.
Well, I don't know. You just have to take my word for it that she called me. I mean, you tell the court I'm representing somebody, the court generally takes your word for it.
Well,
I told the court I was representing her. Nobody can deny that. I don't believe we'll deny that she wanted me to. Called.
Did not Ms. Gaskins at this point in time have both a guardian ad litem and an attorney ad litem representing?
No, sir, because they were appointed under that emergency petition, and they was declared void. Okay, and when you declare the emergency petition void, that attorney ad litem is void from that. That's a statute. The statute says they're voided, okay?
So today, who are you representing?
I represent Ms. Gaskin and also represent my Mr. Warner because he had a power of attorney.
Haven't you been disqualified by the trial court representing Mr. Warner?
Say that again?
Did not the trial court disqualify you?
Yeah, they disqualified me from evidently representing Mr. Warner.
That's my question, yes, sir.
Yeah, but there was no hearing on the disqualification. There's no pleadings in it, no motions in it, no hearing on it. There was no finding of facts, nothing in that respect. And you just don't, according to law that I read, you got to have more than just an allegation or something like that. Matter of fact, this court, Ms. Valerie Smith, you remember, had a case that just passed spring, okay, on this issue, and she said the other side, the plaintiff petitioner, had to show some reason why I should not be qualified as should be disqualified. It's in Summers, I cited in the petition, but it's in the Susan Malone, I believe, cases. It was just heard in April of this year, or decision was rendered in April this year. There's other cases that when you do use this tactic, okay, sometimes they say that you have to look at it very carefully, because that can be a tactic that can be used to cause havoc to the other side when you use this tactic without really having a reason for it. There's several cases I've cited in my briefs where they've tried to disqualify attorneys, but yet they let them go forward in this case. But the main thing on this case here is the durable power of attorney. It's valid. Still hasn't been declared invalid.
Jury, didn't the court set aside?
I'm sorry?
Didn't the court set that aside? The
September of
durable power
22 is
attorney?
when it was filed.
Yeah.
I mean, executed, September of 22. A year and 4 months or so before all this incident occurred.
But does a trial court have authority under our state statutes to revoke
To revoke, but they,
a durable power of attorney?
but they didn't revoke it. They didn't have, it says for good cause. Good cause. There was no hearing.
But is there an order revoking the durable power of attorney?
I'm sorry?
Is there an order that revoked it?
No.
Are you sure about that?
I didn't see an order that revoked the power of attorney that I remember.
Okay.
The judge just passed, we had a discussion about it before the trial date, and he never did come to a conclusion on it. My position was that it was valid, and he never would make a decision on it. And so on the trial date then another thing, this trial date was on 6 days after she was served. And she wasn't even, my client wasn't even, Ms. Gaskin wasn't even properly served because it didn't comply with the statute. And these statutes dealing with this are mandatory. They're not discretion or presumption. They say must in them. Must do this and must do that. None of these were done. And the hearing was held. The statute says 7 days is a minimum to 60 days. It was heard on the 6th day. She was served on the February the 8th, and the hearing was on February the 12th. At that time, I was discharged. That's when the order was signed, I believe, just saying I couldn't represent anybody.
Your time is up.
Okay.
Thank you.
Good morning, and may it please the court. My name is Ricky Herbert, and I'm an attorney from Tipton County, Tennessee, from the bar in Tipton County. And I represent the appellee.
Would you pull that microphone down a little bit?
Apologies.
Thank you.
I represent the appellee, Miss Rachel Swanner. Before I get started, I would ask that the court consider that they should dismiss this appeal as it is not properly before the court. Attorney Jimmy Drury has alleged that he represents both James Warner and Miss Gaskin, both appellants in this case. However, Miss Gaskin had counsel in the lower court, the attorney ad litem, and has not authorized this appeal either through her attorney ad litem or through opposing counsel. Additionally, James Warner was never actually a party to the case in the lower court. He never properly filed a motion to intervene. He never had that motion to intervene granted. While he did file pleadings in this case, this court has held that merely filing pleadings is not sufficient to establish yourself as a party to a case, and that you do require an order granting an intervention to be considered.
Well, what about the statute itself that says that you've got to give notice?
Yes, Your
and
Honor.
To, in the petition and to, let's see, the nearest relative, I suppose, and the statute, I mean, the petition itself lists him.
Yes, Your
Does that
Honor.
not make him an involved party in this?
No, sir, I do not believe so without a proper motion to intervene in order granting that intervention. While the petition did give him notice, and while Mr. Warner was provided notice of the action that was at hand, that then opened the door for him to come in and intervene in the action, which he never did.
So if he files pleadings, if you give him notice, and the statute requires that he receive notice, and then he files pleadings, he's not a participant in the proceeding?
Not without an order granting an intervention, Your
Sounds a
Honor.
little illogical to me.
Your Honor, and I may just have to concede that point, but it was my understanding from the statute that while it gives notice to all of the closest relatives, it does not automatically implead them as a party to the case.
Well, what would be the purpose of giving him notice then?
To avoid any kind of corruption, to avoid conservatorship abuse, and to safeguard the rights of a party by notifying their family members in the
Require them
event.
to participate in the conservatorship, would it not?
Yes, Your Honor. And Your Honor, alternatively, should this court determine that Mr. Warner had standing to come into this court even without a motion to intervene or an order granting such intervention, this court should alternatively hold the findings of the lower court and hold that the lower court acted completely within its jurisdiction and used its discretion appropriately, and not only appointing a conservatorship over Ms. Gaskin, but in determining that the medical evidence provided was sufficient to establish such conservatorship, and that the court was correct in holding that the healthcare power of attorney dated in September of 22 and the power of attorney dated in January of 24 were both void.
Did the trial court actually make that finding?
They did, Your Honor.
In which order?
I believe it was the order from the hearing on February 8th, but I do not believe that order was actually entered until February 14th.
Okay.
I may have those dates.
We have that order in the record?
Yes, Your Honor.
Okay.
I
And
may
the
have
trial
those
court-
dates.
The trial court directly addressed both orders then?
Yes, they addressed that they were, I believe under the initial order under the emergency conservatorship, the court ordered that in the event any healthcare powers of attorney or durable powers of attorney were in existence, that Mr. Warner was enjoined from acting under those. And then later, whenever they established a full conservatorship, held that any powers of attorney in existence were deemed void.
And which order does that?
The final order that the lower court entered on the conservator, which was on February 14th.
Okay, I'm looking at that order. Can you show me? Is there language in that order?
I believe one of the paragraphs, and Your Honor, I apologize, I don't have it in front of me.
Okay.
But there should be a paragraph towards the end of the order, which states that any powers of attorney held by Mr. Warner or any other party were declared void.
Okay. Go ahead.
Thank you, Your Honor.
We'll look at it and make sure.
Your Honor, the lower court had ample authority to remove the emergency conservator. One of the points that opposing counsel has argued is that Ms. Gaskin had to proceed in this conservatorship proceeding without counsel. However, that's incorrect. The emergency conservator petition was never dismissed. The order granting Ms. Swanner's emergency conservatorship position was not set aside. However, her specific appointment was voided. Nothing else in the order appointing that concerned the emergency conservatorship was set aside other than her appointment, and her appointment was properly set aside because of insufficient service. Her service on Ms. Gaskin had been obtained by providing service to her attorney ad litem on on January 29th. However, the court, upon reviewing this, determined that that was improper and that she did require personal service. So she was personally served on February 8th by private process server. This came after she had already met with her attorney ad litem, met with her guardian ad litem, and filed an answer in this cause. And all of those reports never once indicated that she required alternative counsel, never indicated that she was uncomfortable or dissatisfied with her counsel that was appointed, and only indicated that she had no recollection of signing any documents and including of any kind of legal significance, had no recollection of signing any letters, and additionally stated that she didn't believe she needed a conservatorship, that she intended to take care of herself. Now, those statements came contradictory to the documents which were provided to the court by Attorney Jimmy Drury, who had not only stated to the court that he typed those letters as dictated to him by Ms. Gaskin and took them for her to sign, but also had her sign a durable power of attorney just days before this emergency conservatorship was filed.
Now, let me ask you the same questions I asked Mr. Drury. We don't have a statement of evidence. We don't have a transcript. Is all this that you're telling me in the record?
Your Honor, I do believe that's been one of the harder parts of this case, is that we don't have the benefit of having a transcription from what occurred in the court. I do not recall if there's any pleadings that outline those details. However, the letters, including the signatures there too, and the healthcare power of attorney and the durable power of attorney, are dated and do have Mr. Jimmy Drury's information on them, which I believe would show to the court that he was the author of those documents. But Ms. Gaskin not only had counsel to advocate for her interest, she also had a guardian ad litem which was appointed to represent her best interest and to safeguard any attempts against an unnecessary conservatorship or against any abuse that she may be susceptible to by way of her disabilities. But she never made any request for alternative counsel, not through the guardian ad litem and not through the attorney ad litem. She made no complaints of insufficient counsel, and even today has not made any complaints of insufficient counsel. And she specifically made statements to the attorney ad litem and the guardian ad litem that directly contradicted the statements that Attorney Jimmy Drury made allegedly on her behalf.
Let me ask you, do we have any medical records that are part of the record that will justify the appointment of a conservator in this case?
There was a sworn medical affidavit which was attached as an exhibit to the petition for the appointment of an emergency conservatorship and the appointment of a conservatorship in general. And that that sworn affidavit, we believe and propose, is sufficient to constitute the appointment of a conservator.
Is that what the trial court was referring to when it says that the doctor's affidavit is approved?
Yes, Your Honor.
It doesn't go on to state the findings by the doctor in terms of the ward's condition.
No, Your Honor, I do not believe the court's order outlined what the doctor's findings were, but that is a part of the record and can be found. I believe it's attached to Exhibit B.
Is this the document that was filed January 22, 2024, that's styled medical examination report?
Yes, it should be as an exhibit to the petition.
Okay.
But under TCA 34-1-126, that statute requires clear and convincing evidence of a full or partial disability and the need for a conservator in order to appoint a conservator. Under 34-3-104-7, it outlines the requirements of a petition and states that any petition for a conservatorship appointment must name the physician. It must also identify any other disability that the party has, and it must be a sworn statement by the doctor. And it references another statute, 34-3-105C, which more specifically outlines the requirements of that sworn affidavit. It requires that the affidavit be completed no fewer than 90 days from the filing of the petition, which this document was. It also requires that it be sworn to, that it outline the medical history and any current diagnosis of the respondent, that it describe the nature of the disability and the things that a ward may or may not be able to do based on what the doctor's evaluation of the ward was.
I hate to ask you to do this. Do you have that medical examination report in front of you?
I do not, but if I may grab my binder, I can certainly.
Please.
I believe I have a reference to the record in it.
What I'm trying to figure out is in subpart D, what the last date was that the doctor examined the patient?
Your Honor, I believe it was December 18th of '23.
Is that December or is that February?
It's December. There was some dispute over that in the trial court level, as attorney Jimmy Drury had maintained that it said February, but there is a 1 in front of the 2.
Okay. Did the trial court make a finding on that?
I don't believe it's written in any order, but the trial court did have open dialogue with the attorneys and came to the conclusion that it was indisputably.
Again, we don't have a
December.
statement of the record or a transcript.
Yes, Your Honor. However, Your Honor, that medical evaluation, we believe, falls squarely within the requirements of the statute, and gave substantial insight to the court of what Ms. Gaskin's abilities were and were not, and whether or not she needed a conservatorship. Additionally, opposing counsel has argued that the medical affidavit as provided should not be relied upon because it was contested. However, there's no record of what parties contested this affidavit. Mr. Warner never filed any documentation saying he contested it, and Ms. Gaskin never contested it. However, in addition to simply contesting the affidavit, the statute requires that it also be found to be an error by the trial court, and the trial court declined to make that finding. Additionally, this court should hold that the lower court acted within its discretion in voiding the healthcare power of attorney and durable power of attorney, while opposing counsel states that there never should have been a conservatorship petition because there was an existence of a healthcare power of attorney. The petition as filed clearly outlined that Ms. Swanner, the appellee, was not aware of the existence of these documents, but believed that there may have been a healthcare or durable
How do
power
we
of
know
attorney.
that?
I'm sorry?
How do we know that?
It was in the petition.
The petition?
Yes,
Who
Your Honor.
filed the petition?
I filed the petition, Your Honor.
Not,
And Ms. Swanner swore under oath that she believed that there may be in existence these documents, but she had not seen them.
so your client filed the petition saying that the ward didn't know certain things.
No, Your Honor, I apologize. She filed a petition stating that she, as the petitioner, was not aware if there was a valid healthcare power of attorney.
But we don't know what the ward knew, right?
We do not, but
And we don't know, did the trial court give a basis for why it was voiding these documents?
I believe based on the recommendations of the guardian ad litem, the court believed that, which is not part of the record.
It's not part of the record. So we don't have any reasoning as to why the trial court did a lot of the things the trial court did, do we?
No, Your Honor.
And even if it's an abuse of discretion, don't we need to know why the trial court acted a certain way or why the court ruled, so we can ascertain whether or not the trial court abused its discretion?
Yes, Your Honor, and I believe had a transcript been provided upon the appeal being filed, that the court would have substantially more insight as to what occurred.
I would totally agree with you on that,
Yes, Your Honor.
or I would hope that that would be accurate.
Yes, Your Honor.
What about the hearing that was held less than 7 days after giving notice? Is there authority for the trial court to waive that requirement?
Yes, Your Honor, there is. So there are 2 separate statutes which outline the time frame for a emergency conservatorship and a regular non-emergent conservatorship. However, and at this point, we were under the non-emergent conservatorship portion, which is governed by 34-1-108 as far as notice. And that statute does require that any hearing on a conservatorship petition take place within 7 and 60 days from the date of filing. However, if you read further onto subsection B of that statute, it allows that a trial court has discretion to shorten that time period if the parties have actual notice, the relatives to the respondent have actual notice, and there is a life-threatening situation. And the court believed, based on the statements and testimony provided at that time, that they needed to make a determination as to a conservatorship before the respondent was discharged from the nursing home.
And did the court make any findings in its order about this being a life-threatening situation that required the hearing to be held earlier than 7 days?
Your Honor, I do not believe that exact language was found in any of the orders. However, the court noted the urgency in the matter.
We have no way of knowing what was noted.
Yes, Your Honor.
Okay, all right.
All right.
Your time is up.
Thank you.
Your Honor, counsel said the court has the right to shorten these time periods. My understanding of what shall and must means is that it's mandatory. You can't do anything with it. It's not within your discretion to do that. This TCA 346204, well, no, that's not the one. The one about the 66 days, it says the hearing on a petition shall be held not less than 7 days. It says shall be. Shall is a mandatory.
Did you read that statute? She
Yes, sir.
cited
Yes, sir.
34-1.
34-1.
108B.
108, the very first sentence.
No,
very first sentence, A part.
108B.
Yes. Hearings on petition, notice. Part A, except as provided in subsection B, the hearing on a petition shall be held not less than 7 days nor more than 60 days from the date of service. B part, it's got to be a minor with a minor. It involves a minor, not an adult. Okay? And also
You don't see the part where it says if it's a life-threatening situation, that you can hold a hearing in less than 7 days. You don't see that there in the statute, Mr. Drury?
the one I've got says 34-108 says the very first A part says on the short, you'd like to see it.
No, I've looked at it. You need to read B, subsection B, and you'll see that the trial court has authority to hold a hearing in less than 7 days.
Which part are you referring to?
B.
C?
B.
D, okay.
No, B. B is in ball, not D as in David.
B is in dog?
Okay.
I don't have it. Well, I think it says if it's an emergency or something like that, doesn't it? Say that part in D?
It's a part of B.
Huh?
It's a part of B.
I'm sorry, I only did the first two parts because I thought that was all
Okay.
applicable. I don't have D. I don't know what it says, to be honest with you. But I think the D part, if you waive it, it's got to be, you got to have some kind of grounds to waive it, I would think. I don't know what the grounds were to waive it. I mean, she was in the hospital. She's in rehab. Okay, when this come up, she's about ready to get out. She got out the 15th. This is on the 22nd. What was the reason for?
Was she in a condition where she could go home and live alone, Mr. Drury?
What?
Let's say if she was released from rehab,
Okay.
was she competent enough to go home and live alone?
Well, if she wasn't, she had the power we had an power of attorney in fact to live with her. Well, we could make arrangements where we turned in an application to, in case there was a conservative appointed, other than the power of attorney in fact being existent, that she could, we had arrangements for somebody to stay with her for a while. Besides, she had a very good neighbor that was seeing after her when this plaintiff, the petitioner, was out on her trips and everything. It was set up when she got home to take care of her on the 15th. No question about that. I think it's in the file where we filed something saying that we had somebody who was qualified to stay with her and was planning on staying with her. Yes, we had that. That's in the file.
Your time is up. Your time is up. Thank you.
Thank you, sir.
Thanks to all of you.